Again, welcome to folks who may now be joining us for part two. And, as part of part two, we're going to hop into the pre-application review process. We'll also be covering the location compliance and sensitive uses, the pre-application review workflow and the different forms, ineligible locations, different sensitive use restrictions, and some general zoning restrictions. We'll just be doing a brief overview of the fees associated with the pre-app review, and then some resources available to social equity applicants, and then a few of the deadlines that are pertinent to the pre-application review process. So again, we are recording this session, and the recording will be available on DCR's website sometime next week. We will have the different parts of the presentation bookmarked. So if you have to drop or you miss something, you can always come back and listen to the recording at a later date. So thank you all for joining tonight. So what is pre-application review? The pre-application review process was created based on feedback from applicants. Applicants were concerned that they had to submit an application and have executed leases and other things necessary to submit the application before they even knew if their location was eligible for licensure. So what the department did was we worked with policymakers to pull the vetting of the proposed business location out of the temporary approval application process, and we established a standalone pre-application review process. So as part of that pre-application review process, what we do is we look to determine whether or not a proposed location or parcel complies with LAMC 105 and the different eligibility requirements. And you do not need to have site control in order to go through that review. And the goal there was to give applicants peace of mind that they can move forward at a proposed location before they actually submitted the application. And that's kind of important because a lot of the applicants that are coming in now are social equity applicants, and they don't have the ability to hold a location for months at a time while they go through this process. So right now, if you're looking to apply for retail storefront, non-storefront delivery, non-volatile manufacturing, distribution, any of the cultivation processor, the nursery type testing labs, before you can submit your application, you'll have to go through the pre-application review process. And that's where we'll determine whether or not the proposed business premises location is eligible under LAMC section 104.3A3, and does it comply with LAMC section 105? LAMC section 105 deals with the distancing requirements and sensitive uses that DCR has to look at before we can issue a license. So again, as part of the submission for the forms and docs, we only require the landowner attestation for location eligibility, and that's the landowner attesting that the business premises was not subject to any of the reasons that could disqualify the business premises from DCR issuing a license for those business premises. And really, that's information that the landowner would know, not necessarily the applicant. So we do require for the landowner attestation to be filled out, because that's really the applicant's peace of mind that there wasn't unlicensed commercial cannabis activity or some other activity that was cited at the location prior to you executing the lease and trying to move forward in this process. We do have resources available on our website. We have the review workflow, which we'll go over, and then we also have an information and procedure bulletin associated with this process. In terms of the workflow, when the pre-application review record gets created, we issue an invoice for the pre-application review. Again, if you're a phase 3 retail round 2 applicant, we do have grant funds to waive that fee, so you're not required to pay the invoice. And for other social equity applicants, we were deferring that fee in advance of the state's March 31st deadline so that DCR could immediately begin its review of the record to assist you in getting a notice of local compliance underway in the environmental letter that the state required for their provisional license process. Generally, once the invoice has been issued for the $597, you have 30 days allowed by code to pay the fee. Your record status goes to waiting for payment. And then once you've paid the fee, we will workflow your record to pre-application filed, and then we'll begin the land use review. As part of that review, we look to determine whether or not the location is compliant and eligible. In terms of compliance, we're looking at compliance with LAMC section 105, and then we rely on the landowner attestation to determine eligibility. If you're ineligible, you'll get a notification through the system that basically shows that your record is ineligible for further processing. If you have questions about the ineligibility, you can always reach out to your licensing analyst or DCR licensing at lacity.org. If the record is eligible for further processing, it gets workflowed eligible for further processing, which then enables you to submit your temporary approval application. And you do have up to 1 year to submit your temporary approval application. So if, you don't have to have an executed lease or anything else to go through this process, but you do have to have an executed lease to submit your application. So this gives you time to negotiate with the landlord, complete any other business-related decision-making that has to happen before you submit your application, because the goal is once you submit the application, it can be quickly processed to reduce your holding times. So this is just a larger screen print of our workflow. And again, this is available on DCR's website, so I'll just leave it up for a few seconds. But if you want to see the workflow and the IPB, I do recommend you go to DCR's website to see this. An IPB, or Information and Procedure Bulletin, kind of outlines what the process looks like. And it's a quick walkthrough of what we do as part of the different processes. So what I would encourage you to just go ahead and read this Information and Procedures Bulletin at your leisure so that you can better understand the process and what the next steps would be once you complete the process. In terms of looking at sensitive uses, we rely on publicly available data, and that data may be maintained by a state or a local agency. We pull the data on a quarterly basis, and that data is used for the entire quarter. A sensitive use that pops up after you submit your pre-application review record will not be included in the land use review. Once we have determined that your location is eligible for further processing, it does protect your pre-application review record and any application you submit within the 1 year period from future sensitive uses for up to 1 year. It is important to note that sensitive uses include libraries, parks, licensed daycare facilities that are not on a residentially zoned parcel, drug and alcohol treatment facilities that provide on-site non-medical residential rooms. We have permanent supportive housing with on-site services. And that's just a few of, and of course, schools. And those are the primary sensitive uses. If a location is identified on the DCR licensing map, it may not rise to the level of being a sensitive use. We pull the data from the different government websites, and then we provide it to the Department of City Planning to map it. So our DCR licensing map on our website is really a tool to help you as a prospective applicant identify potential sensitive uses that may preclude DCR from deeming your pre-application review record eligible for further processing. Libraries, parks, that's maintained by City of LA agencies, and you don't really see a ton of new libraries and parks coming online. So that information is relatively static. In terms of daycares, drug and alcohol treatment facilities, schools, permanent supportive housing, those things change, and they may change quarterly. They may change monthly. They may change day to day. So the reason why we pull the data on a quarterly basis is it's too hard to review information that changes day to day, and it doesn't give applicants, especially the social equity applicants, the peace of mind to get into the process, because it's an ever-changing landscape, and you don't want to pay fees and make business decisions on a parcel that a day or two from now may no longer be eligible. So what we worked with the city council to change the point at which we make the land use determination from the time we're ready to issue the license to this pre-application review process to give folks peace of mind. And of course, we remove the requirement for folks to have site control in order to allow them to go through this process without actually having an executed lease or site control of the property, so that one, it reduces holding costs, and two, in the event that it's not eligible for further processing, that you won't be out of pocket anything more than the $597 pre-application review fee. So for the four major land use considerations, we deal with the eligibility requirements under 10403, and that's dealt with through the landowner attestation. We look at the distancing of the proposed business location for sensitive uses under LMC section 105. If applicable, for the retail storefronts with on-site sales, we have to look at the distancing from other commercial cannabis businesses that also have on-site sales. It's either a licensed location, a location that's paid their temporary approval application fee, or a location that has pay their business premises relocation fee. That's when those entities plant their flags. Now, commercial cannabis businesses with on-site retail sales are not considered a sensitive use. So when we do our land use review and we deem something eligible for further processing, it is not guaranteeing you that another commercial cannabis business can't move in, because those businesses can continue to move around until you as an applicant have planted your flag. And applicants plant their flags when they pay their temporary approval application fees. So you need to be mindful of that. And then the other piece is the zoning requirements under LAMC 105. So business premises are ineligible if they're owned or managed by a person who holds office or agency in the state of California or any of its subdivisions. The business premises was the site of illegal volatile cannabis manufacturing under Health and Safety Code 11379.6. It was the site of distribution of cannabis to minors. It was the site of illegal commercial cannabis activity after April 1st of 2018. It was the site of a disconnection of utilities under LAMC section 10415E. It was the site of padlocking under 10415.1. So generally, applicants won't know whether or not the owner of the parcel, of course, is a government employee, they're engaged in commercial cannabis regulation, whether or not the property was subject to convictions for any of the things that would disqualify it. Therefore, the landowner attestation is really the applicant's peace of mind that the landowner is attesting that that location wasn't subject to any things that would disqualify DCR from an issuing a license to the applicant at the location. So it's really for the applicant's benefit to get that landowner attestation filled out and taken care of. When we start getting into the distancing requirements for businesses with the retail storefront on-site sales, they have to be outside of a 700-foot radius of a school, public park, public library, alcoholism or drug abuse recovery or treatment facility, daycare facility, permanent supportive housing, and any other licensed retail storefront with on-site sales. For the non-storefront retailer activities, whether it's delivery, distribution, cultivation, non-volatile manufacturing, testing labs, you just have to be outside of a 600-foot radius of a school. And then we haven't accepted any volatile manufacturing applications, but if a volatile manufacturing application, when they get submitted, they'll have to be outside of a 600-foot radius of a school and a 200-foot radius of any residentially zoned parcel. I'm going to just briefly go through this. Basically, the retailer and micro business activities with on-site sales have to be outside of 700 feet from one another, as well as the sensitive uses. And the distancing generally is a straight line without regard to intervening structures from the closest exterior wall of the commercial cannabis business to either the parcel line or closest exterior wall of the sensitive use. And it comes down to whether or not the sensitive use has full site control or they have partial site control of the parcel where the activity is occurring. Commercial cannabis activities can only occur in certain zones within the city. This information is available on our website, and I'll just briefly go through some of the zoning. For the retailer with on-site sales, generally it's allowed in commercial zones and manufacturing zones, not including restricted manufacturing zones, which are MR. For the micro business with on-site, they are only allowed in the manufacturing zones. For the micro business delivery, which does not allow on-site, so no on-site sales, they can locate in the M1, M2, M3, as well as the MR zones. Anything with on-site sales is not allowed in the MR zones. So make sure when you're looking for proposed business locations, you're not looking at MR zones if you're planning to apply for the retail storefront activity, because that's going to be an automatic ineligibility if it's located in an MR zone. There are no variances, there are no other processes available to allow for DCR to issue it in an MR zone under current law. Only EMMDs had limited grandfathering to continue to operate in an MR zone, and that limited grandfathering is set to sunset in the next couple of years. So all new applicants will not be allowed and have not been allowed to locate in the MR zones for retail storefront with on-site sales. For cultivation, you're looking at the MR and M zones. Same thing for manufacturing. For testing, they can be in a commercial manufacturing zone, an M zone, or an MR zone. For distribution, they can be in the M and MR zones. It's kind of important just to understand what the general zoning restrictions are, and that's one of the reasons why we limit what types of activities can be applied for on the same record, is to really allow for the land use review to focus on things that are compatible. If you apply for multiple activities and one of the activities is not compatible with the zoning or the distancing requirements, the entire pre-application review record is deemed ineligible. And if you want to make modifications to the activities, or you want to change what your proposal is for what activities and where they're going to occur on the parcel, you'll have to submit a new pre-application review record. So we look at the eligibility criteria based on the landowner attestations, and then DCR staff actually do the measurements and do the review of the zoning and distancing requirements within our system. So all of the pre-application review records are submitted online via the DCR licensing portal. Before submitting the pre-application review record, you are going to have to make sure that you have a legal business entity record. If you are planning to pursue as a legal business entity, otherwise you can apply as a sole proprietor. And if you're a verified social equity applicant, then you can apply for the activity types that are limited to social equity individual applicants. Once the record is created, as I mentioned, the $597 fee is applied to the record, and an invoice is generated. If you are eligible for a fee waiver or a fee deferral, please don't pay the invoice immediately. For the fee deferrals, you will have to pay the invoice and outstanding fees at some point in time. So it's up to you whether or not you paid immediately within the first 30 days or you request a fee deferral. And for the folks that have the fee waivers, such as the Phase 3 Retail Round 2 applicants, once staff identify the pre-application review record is associated with the Phase 3 Retail Round 2 applicant, they'll go ahead and waive the fee. So don't worry about paying the invoice. If you have questions about whether or not you're eligible for a fee deferral or a fee waiver, please reach out to the department before you pay the invoice. If the proposed business premises is compliant and eligible, we workflow it to a status of eligible for processing, which then allows the applicant to submit an application. Right now, we're allowing folks to submit temporary approval applications. Beginning on May 1st, we'll be allowing folks to submit annual applications. And the requirements and documents for both are going to be a little bit different, and we'll cover that in Module 2 and Module 4. Once the pre-application review record has a status of eligible for processing, you have up to 1 year to submit an application, whether it's a temporary approval application or an annual application once that process opens. So before I hop into public convenience or necessity, I'm going to go ahead and show you some of the mapping tools in the zoning information map access system, as well as the DCR licensing map. So bear with me as I transition over. So I'm on the DCR licensing map page, which is part of DCR's webpage. This page is available under the licensing tab. So if you go over to the little sandwich menu, you go to licensing and go licensing information, licensing map, you'll be able to get to this page. On this page, we have an embedded map. My preference is to view the map in a new window, which I'll toggle over to in just a second. But the map has different information available to you. So in the find an address, you can type in an address and it'll move the map there. And then over here under our layer list, we have different options and different information, such as pending applications, modification request, locations with temporary approval, social equity businesses. And then we've got the data that we pull from the different government agencies related to childcare, treatment facilities, schools, et cetera. So I'm going to pop over to the full screen map. As you can see, I've already dropped City Hall and City Hall East into the map, so I'm here. So what I'm going to go ahead and do is I'm going to toggle on the different options that we use as part of our land use review. And then just go ahead and close this out. So you can see that there's a park. There's a park right over here. There's also a daycare facility, Joy Picus, right here. So if we were doing a land use review right off the bat, we would say there's potentially sensitive uses there. And then we would go to our list of sensitive uses to see whether or not it meets the requirement for it to rise to the level of a sensitive use. So, you know, the City Hall Park is actually a recreation and park facility, which is right over here. So we know that that would be a disqualifier. Joy Picus is also on the list of licensed daycare facilities. So what we would do is we have the address here. 111 East First Street. I'm going to go ahead and toggle over to ZIMAS, and then I'll show you what we do in ZIMAS. So bear with me. So now I'm in ZIMAS, which is the Zoning Information Map Access System. And this is the City Hall East and City Hall South complex, and Joy Picus is right here in the City Hall South complex. This parcel itself is a public facilities parcel. So it is not residentially zoned, which means that given the fact that Joy Picus has a state license, and it's not located on a residentially zoned parcel, it is considered a sensitive use. And then that would further disqualify a retail storefront business from locating at this location. Just toggling back to our map here. However, if we zoom out a little bit, what we see is there's a homeschool or something associated with this, which you can see here is not a legitimate address here. So that would not be considered a sensitive use. And if we zoom out a little bit more, you don't see a school within 700 feet. So although there's a park and there's a daycare facility that would disqualify that parcel for retail storefront with on-site sales, we could issue a license for non-storefront delivery, testing, non-volatile manufacturing, cultivation at that location. So that's some of the stuff you're going to want to look for. The next thing, of course, is when you get into ZIMAS, whether or not the parcel is properly zoned. And because it's zone PF, which is not one of the zones we can issue licenses on, we wouldn't be able to issue any commercial cannabis license, which is why generally we do the zoning review first, because if the zoning is off, even if it's properly distanced, we can't move it forward. And if I zoom out, ZIMAS has a few different mapping options. One of the nice tools is under the different headers on the left-hand side of the page, you can get information about a parcel. So you can see the different legal addresses associated with the parcel. You have the ability to look at the APN number, which is something that you may need for your state application. You have the ability to look to which community plan area it's located in, neighborhood council, the council district. You have the ability to view different building permit information. You can click on the tab, you can see what types of permits have been pulled, certificates of occupancy, other things for the parcel. You have the ability to look at the zoning. You can see here it's PF for public facilities. You can see whether or not it's a C zone or an M zone. You have the ability to identify if it's in a community overlay area. And then later on, you have the ability to look at public safety related stuff in terms of which bureau or division the local police station and fire stations are in. That will come in handy as part of the PCN process, which we'll jump into next. Some of the other helpful things are within ZIMAS, if we do have to do some type of mapping tool, we can look at the radius option here, which is a circle. And depending on if it's retail storefront, we can do a buffer of 700 feet and it'll draw the blue line and it'll highlight any of the parcels that fall within that 700-foot radius. You do have to remember it's mapping from the parcel line to create that radius versus when we're doing our mapping, we're looking at the closest exterior wall. So this is just an initial tool to identify if any of those sensitive uses are triggered before we get into the more exact mapping tools and the distancing, which is over here. For anything other than retail with on-site, the buffer is going to be 600 feet. So that's the general buffer we've been using a lot. And you can do a couple of things with this. They have options to change the background displays. So if we do have to get into mapping, I would typically toggle on the digital color aerial maps so that we can see where the footprints are for the different business and any of the other structures that are on the parcel. And then this, of course, comes into handy if we're doing any types of measurements. So hypothetically, you know, if we were applying for any type of commercial cannabis activity and the activity was in this corner of the building, that would be the exterior walls that we would be measuring from. This little button over here, the measuring tool, you can actually click on a piece of the parcel anywhere in the map, and then you can drag it over to where you think the sensitive use is or where it's identified on the map. And then when you double click on the endpoint, it will actually show you the distance in feet based on these mapping tools. So this is a tool that DCR staff use on a daily basis to do these land use reviews. In addition to the licensing map and the publicly available information on the DCR website. There's no tricks, there's nothing hidden. The mapping tools that are available to prospective applicants, their consultants, and their law firms are the same sets of tools DCR staff use on a daily basis to make these land use determinations. So the information we're using is information that you can access and use yourself prior to submitting these pre-application review records. So those are just some of the tools. Again, within our map for any of the sensitive uses that pop up, you should get information about what the name of it is, the type of sensitive use it may be, and a particular address for that. And this, of course, is information that DCR staff uses to review against the state list that we pull and to look to see whether or not it rises to the level of meeting the definition of a sensitive use. So again, just because you see something here on the map, like we identified with the school that's not actually here, this is intended to allow you to do your own due diligence. And then, of course, even if something's there, we do review that information to see if it does rise to the level of being a sensitive use before we make our land use decisions. So we'll probably get some maps or some questions related to that a little bit later. I'm going to go ahead and pause my screen and transition back to our presentation. So just bear with me one sec. So one of the changes that was made previously was moving the public convenience and necessity process to after the pre-application review process. When the city had its public convenience or necessity pilot program, the code was written in a way that did not allow DCR to process any aspect of the application before the PCN request got submitted to the city council. So somebody could go through the full-blown the PCN process, have the council make a finding of public convenience or necessity, and then DCR had the authority to begin processing that application. And for at least one of the records where council made the finding of public convenience or necessity, when DCR began the review for land use purposes, we determined that the location was too close to a sensitive use, and we were unable to move the application forward in the process. So you can imagine that that prospective applicant was very unhappy that they went through the time and effort of getting a PCN request only to be told later on that their location was too close to a sensitive use and they couldn't submit an application or pursue licensure at the location. So we worked with the city council to amend the policy to allow DCR to do the review of the pre-application review record. And then if we make a determination that it is subject to a finding of undue concentration, then to allow the applicant to enter into the public convenience or necessity process. So now I'm just going to take a couple of minutes to run through what that process will look like now. So any applicant seeking to engage in retail storefront with on-site sales, cultivation, and volatile manufacturing in a community plan area that's unduly concentrated, which we refer to as a finding of undue concentration, would have to file a request with the city council and get a public convenience or necessity finding prior to DCR accepting the application. I just do want to note that the PCN process is not available at this time, and hopefully it will open up and be available later this year. We do have an information and procedure bulletin about the public convenience or necessity process. It was last updated in October of 2020. It reflected the process that was in place for the pilot program. It will be updated to reflect the new process and how we start making these determinations prior to us reopening the public convenience or necessity process. And we'll be working with the Planning and Land Use Management Committee and other stakeholders and policymakers over the next few months to get their input about the process and then hopefully open it up. Generally, as part of the PCN process, once we've, this is the actual original workflow, what'll happen now is folks will go through the pre-application review process, and if we find that it's subject to a finding of undue concentration, the prospective applicant could engage with stakeholders, fill out the necessary stakeholder outreach forms, complete the PCN request form, and then upload it via the DCR licensing portal. You would be invoiced for the PCN filing fee, and then once the fee gets paid, DCR would review the information for completeness, and then we would transmit the PCN request to the office of the city clerk, and they would assign a council file number. And then the city council has 90 days to make the necessary public convenience or necessity finding. If the city council does not make the finding within 90 days, the PCN request is denied by operation of law, and it results in us closing out the PCN record. If within the 90 days, council makes the PCN finding, then DCR has the ability to allow the pre-application record to move forward, and then you would be able to submit an application. So really the only difference in this process is the pre-application review is going to come first. You'll have peace of mind that it's properly distanced from sensitive uses. Remember, other commercial cannabis businesses with on-site sales are not considered a sensitive use. So, you will have to make sure that you don't have any competitors within 700 feet prior to submitting your application. But once you get through this process, if you get the finding, you'll have the ability to submit the application, whether it's a temporary approval application or an annual application. The PCN request form is available on DCR's website, as well as the stakeholder input request forms. The PCN finding, this is fairly easy to populate if you use ZIMAS. You can enter the business premises address, you can identify the community plan area, the council district. I would hope you know the applicant name and the contact information for the applicant. You can enter your proposed operating hours. You can enter information related to a business improvement district if it's within one, the local neighborhood council, et cetera. You'll be able to get all of that information from ZIMAS. And that's kind of what I was talking with folks about a little bit earlier is when you get into ZIMAS, the headers that we have tagged are ones where you would be able to glean the information necessary to complete a lot of what's on that public convenience or necessity filing form. In terms of the stakeholder input, there's different stakeholders that you're required to reach out to. So you could indicate which type of stakeholder you're reaching out to. You can put the name of the stakeholder. Some of that information you can glean from the ZIMAS information, such as the substance abuse intervention, prevention, and treatment facilities. If you go to the DCR licensing map, we do have the licensed locations that have the non-medical residential services associated with them, but there may be other ones that are substance abuse intervention, prevention, treatment organizations or facilities that are not there, and you can do your due diligence and reach out to them. It doesn't have to be one of the sensitive uses identified on our map. And then of course, you'll put your council file number. That will be issued to you once you've submitted the form and we filed it with the city clerk. They'll assign a council file number. We will upload that to DCR's website and communicate that to you. So if any of those organizations or stakeholders have public comment that they would like to provide to the city council, they could go ahead and file it under that council file number. The cost for filing a PCN request is $1,592. There may be a written notice fee of $484 if we are required to provide notice on your behalf. And then, of course, we prepare and issue an invoice for the PCN filing fee and any applicable notice fees within 10 days of the PCN record getting created. Again, only certain applicants are eligible to go through the PCN process. Therefore, we have to do the review of the record before we issue an invoice because we don't want people paying invoices for services that we're not going to be able to render. Jumping into the social equity program, the program is intended to promote equitable ownership and employment opportunities. There are a number of services that Dr. Amani Brown and her team are providing: business licensing and compliance assistance. Every verified social equity individual applicant has access to the learning management system. Folks can reach out to the social equity team to find out about pro bono, low bono legal assistance services, one-on-one coaching. We have a job board. We have different workforce development tools. And of course, from time to time, we get state grant monies to provide direct financial assistance to businesses. Our last seed grant program closed on March 31st, and I know Dr. Brown and her team are working on securing additional state funds so that they could do a seed 3.0 to provide further financial assistance to our commercial cannabis businesses. So if you have questions about what programs and services may be available to you and you're a verified social equity individual applicant, please reach out to our social equity team. Upcoming state deadlines that folks need to be aware of. June 30th is the date that DCC has to issue provisional licenses. So if you apply with the state and you're not issued a provisional license by June 30th, you will be routed to the state's annual application process. DCR is going to be transitioning away from temporary approval. So there's going to be a last day for general applicants to file new temporary approval applications, which is June 30th, 2023. And the last day for social equity individual applicants to file a new TA application is July 31st, 2023. There's a 1 month difference there just because the state is processing new provisional license requests, and the state has until June 30th to issue them. And there may be folks that completed our pre-application review process, got their letter of local compliance underway and their environmental document, and they wanted to see if the state would issue a provisional license before they submitted the temporary approval application. So folks have the ability to get peace of mind about whether or not they can get their provisional license before they submit their temporary approval application with DCR. And then of course, we've given them the additional month to get that application in if they are successful in getting the provisional license. So for folks that are not able to get a provisional or temporary approval license, they will have the ability to get an annual license, and our director has really streamlined the annual application process and switched things around to make the process more efficient and then allow applicants to get peace of mind about whether or not they will be issued an annual license before they have to meet all of the other local permitting and business requirements that can come after that process. So we'll talk about that a little bit later in the presentation. Again, we just have some links to the state resources for their licensing process. I do encourage you to reach out directly to the state if you have questions about their process, because they're best positioned to ask those questions. And we were going to go ahead and hey, Gidget, I'm ready to hop into questions if you are.
I am ready. We'll start with the first one from Tiffany W. My question is, at what specific point in the application process is an applicant's 700-foot flag planted?
So the flag is planted the earlier of when a license is issued, when a temporary approval application is submitted and paid for, or when the business premises relocation fee is paid for. So under the original code, a flag was not planted until a license was issued. So, up until the point where DCR was ready to issue temporary approval, you had no land use protections. So that is the original legacy language. Director Garakian and previously Director Packer both worked with the city council to move the needle for when a flag could be planted. And the temporary approval application process and the payment of those fees is one of the earlier ways an applicant can plant their flag. And then for existing licensees that are seeking to relocate, once we've done the land use review to determine that their modification and relocation is eligible for further processing, if they pay the business premises relocation fee, they would be eligible to plant their flag.
Our second question comes from David W. What happens if the lease owner changes their mind on the lease space after you submit it?
So if you're unable to execute a lease with the landlord, or the landlord chooses not to work with you, you have the ability to, if you have an application submitted, you have the ability to submit the business premises surrender form, and then we can abandon your application. And then you have the ability to then refile for the activities listed at another location. If you're in the pre-application review process and you haven't submitted an application, you can withdraw your pre-application, you could cancel it, or it will just naturally time out after 1 year if you don't submit an application.
Our next question is also from David W. How do you submit for a change of lease location, which I think you just went over?
So pre-application review records cannot be modified. We do the land use review based on the location. So if you're unable to move forward at that location, you'll have to find a different compliant location and go through the pre-application review process anew. If you submit an application, your application is not complete unless you have an executed lease or some other form of site control. So if you submit the application, that application may be abandoned if you're unable to gain site control and have an executed lease. Of course, if you have a license, then you have something tangible. And what's happened for folks in the past is they submit their renewal for their license, and then they don't pay their fee, and then their renewal application gets deemed abandoned, and then they have the opportunity to refile. If you do have an active license and you're able to find a new compliant location, basically we can put a hold on your license. So it's not being used, it's not in operation, while you go through the relocation process and then seek licensure at the new location. So there's a bunch of different options depending on where you are in our process.
Thanks, Jason. Moving on, question: Bay City fees that they need to pay from start to finish for a new distributor permit.
You would, if you're, for the land use review, it's $597. If you have to go through the equity share review, that's $1,248. The combined fee for the legal business entity record and the temporary approval application, if you're eligible, is $5,720. There's also a Los Angeles Fire Department inspection fee that goes along with the temporary approval application, and I think that's $1,336. Generally, those are the fees that have to be paid to get to temporary approval. Of course, for the annual application process, where you have to have a certificate of occupancy that matches the activities, you have to get your public health permit, you may have to go and pay additional fire permit fees. There could be additional fees that you would have to pay if you are going to pursue an annual license. But I would recommend reaching out to the Department of Building and Safety for your location and which activities you plan to apply for or pursue. in order to determine whether or not the parcel has the right C of O and other permits for you to pursue that activity, or if you're going to have to make amendments to those documents in order to pursue it, because that will significantly increase the cost.
Okay, our next question comes from Lonel C. I already submitted all of my pre-app documents. It has been 2 weeks. What is the timeline for a response and what's next for me to do?
Yeah, so the pre-application review records are reviewed and moved within 30 days. So we were expediting the review of social equity applicant records that were submitted prior to the March 31st date to help those applicants get their letters of compliance underway. So if it's been in there for 2 weeks, it'll probably be reviewed either sometime next week or sometime the following week, but definitely within 30 days. And then, of course, if your pre-application review record is deemed eligible for further processing, then you'll have the ability to submit your either temporary approval application or beginning on Monday, May 1st, your annual application.
Hey, Jason, we're going to try for a couple more and looking at the time. We have a question or similar question from 2 individuals, Sue Y and Nick S. When will the lottery be drawn again?
I don't have an exact date, but the director is pushing that hold the next lottery sometime later this year.
And then the next question from Kevin B. How do I apply again? I'm trying to get through the application process.
So all of the application related materials are available on DCR's website, and they would be submitted through the DCR licensing portal. And links will be available as part of this presentation, and they're also available on DCR's website.
Can you do one more, or should we stop for a break?
If there's 1 or 2 quick ones, I can get through them.
Okay. What type of, comes from E&E, I apologize. What type of licensing do I need to manufacture, cook and infuse, and only sell wholesale?
So for the manufacturing component, you could do the type N, which is for infusion, or you could do a type 6, which allows you to engage in all non-volatile manufacturing. And for the selling wholesale, depending on whether or not you're going to transport the cannabis products to the testing lab and or to other businesses, you may need to have a distribution license. So at a minimum, you're going to need either a type N or a type 6 to manufacture commercial cannabis products. And you may need a distribution license depending on how you plan to move those products to other licensed businesses. Do we have one more, or should we get ready for the next module?
We do have one more. It should be quick. Javier B. Is undue concentration map in real time?
No. So the undue concentration map, the sensitive uses are updated on a quarterly basis based on the data available on the first day of the quarter. So the next refresh of the map will be on Monday, May 1st. We'll pull the information from the different state and local agencies. And then it takes city planning about a week or 2 to get that data refreshed. And then the sensitive use data will be valid through the next quarter when we pull the new data. For the retail storefront and the different application maps, we try to update those every 30 days. And we're working with city planning and our system programmer, Excella, to integrate the ArcGIS Online account with our DCR licensing portal to try to get the application and retail storefront information updated on a more timely basis. So stay tuned for that. And thanks, Gidget. I'm going to go ahead and progress it. We will be beginning